Thank you. And with that, I think the highlight of the evening is this panel because there's no dinner to look forward to. The other highlight and the good news is that our session time has been cut down from 50 minutes to 25 minutes. So less agony for everybody at the end of the evening. I promise, and on behalf of the panelists, to make it really short and crisp and give you guys the value that you deserve. Hopefully assisted by a little bit of AI and ChatGPT on the background. So with that, getting straight to the topic at hand, what we're going to be talking today is really about reimagining copyrights in the era of AI, generative AI, deepfakes, and the works. And a lot has happened in this space, but before we do that, before we really get into the conversation at hand, a quick quiz for the limited audience that is here. The topic certainly implies that copyright precedes AI, but how many of you, raise your hands if you do, believe that AI as a term was coined before Copyright Act came into existence? Anybody believes that? One person, two people believe that, right? So yes, that is a fact. That's not coming from WhatsApp University. The term artificial intelligence was coined in 1955, and the Copyright Act came into existence in 1957, at least in India. So that is how old the concept of artificial intelligence is. I'll not dive too much deeper into that, but on that note, I think what we really need to start with is the genesis of where artificial intelligence and copyright are in their respective journeys today, and what has really led to this topic or discussion about how copyright, or for that matter, other laws need to change to keep pace with the world today. So Shivaarti, if you can start with your thoughts around that.
Thanks. And it's a pleasure to be a part of this very esteemed panel here at BW. Am I audible? So, I mean, like you rightly said, we have to go back to where it started from in terms of the landmarks in the jurisprudence, if I can say, of Copyright Act. Is one of the very landmark years have been 1914, was when the Indian Copyright Act was there under the Britishers, and then to 1957 is when the provisions of the Berne Convention were incorporated. To, I feel, of course, 2012, and then I feel now is that landmark moment where we are sitting at, with the advent of technology in terms of AI as one of the aspects, wherein major changes will have to be welcomed at the level of the Copyright Act. I'm limiting it to Copyright Act because that is our point of discussion today. So these are one of those landmark moments that we are witnessing because of the advent of technology. And especially in terms of copyright, we need to understand, just to step back, what is copyright? Copyright is basically preserving an artist's right, a creator's right. And we are literally sitting in the middle of a creator's economy, wherein art is not only being created directly by mankind, from the hand and their thought involved, but using other interfaces. Earlier, it was limited to maybe just a camera, and that has been well sorted out in various judgments. But with the advent of AI, which is being fed by big data, it becomes very questionable. Who is the real creator here? Is it the people feeding the big data? Is it the big data? Is it the owner of the big data, or the machine that's being fed the big data? Basis which we get our current results of images, of videos, of faces, and of voices alike. So I think we are sitting in a very interesting time where I personally do feel that this will be a very landmark time for the evolution of the Act as we see it. Since your question was pertaining to how do you see it getting evolved. And yeah, I mean, that's it. Like the other panelists too.
So, one of the big things that is happening is all forms of creativity, whether it is creating text in the form of literary works or even software code for that matter, or audio in terms of sound, voice cloning, etc., or videos, images. Pretty much every aspect of how we consume content, data, or anything which constitutes a creative manifest or work, which is copyrightable, is being generated by algorithms today. And it is being democratized. It's not being restricted to a small segment of society. And since it is all pervasive in the society, I think there's a crying need to act urgently. And there are a lot of gray areas. I'm sure, we'll look at the...
Yeah, like it's very famously said that art cannot be viewed in isolation.
Right.
So if we have to look at the holistic picture, we have to look at the whole chain of its creation. And I think that is where the major amendments and the major changes will lie.
Right, absolutely. And I think, from a legal standpoint or even from a technological standpoint, there are so many other threads to it. It's not just one black box called a computer or software which is doing it. There are so many layers to it. There is, of course, the software, the algorithm, then there are the data sets. Then there are people who've contributed to those data sets on the basis of which some other piece of work is being created. So what are the rights of the people who have contributed towards creation indirectly, by contributing to that lake of big data? So those are all questions to which we don't have clear answers today, unfortunately. But I think, those are the areas where the law needs to evolve, amongst others. On that note, any other thoughts from the panelists on where we are today and where we need to go?
I think generative AI...
So Pavan, we can maybe as a protocol just introduce ourselves
Sorry.
before we speak for the first time.
Hi, I'm Dr. Pavan Duggal. I'm an advocate in the Supreme Court. I specialize in cyber law, cyber security and AI. When I talk about generative AI, and this is what I've argued in my latest book, ChatGPT and Law, that when I look at the terms and conditions, the conditions themselves are indicative of a Pandora's box. Because they are telling you, look, we've given our data till 2021 end, and it's possible that the answer that ChatGPT gives you could potentially be having copyrightable content of other rightful owners. And should you want to go ahead and use it at your own peril, because we are not standing guarantee for it, number one. Number two, they say, look, we are work in progress, so don't sue us, because we are telling you we are work in progress and we will constantly keep on improving our technology. Number three, the more significant stuff is, how do I distinguish actual facts from hallucination? So when I get some hallucinated data or an answer from generative AI, how do I, as a user, dissect it to say, look, this is correct, or this is something which is copyrightable, or is a part of somebody else's intellectual property rights, or this is something that I can actually pawn off as my own. When I look at the terms and conditions, ChatGPT and OpenAI tells you, hey guys, feel free to use my data, but please, if you can give us a small acknowledgement, do say that this is generated with the assistance of ChatGPT. That does not help the situation either way. Because I think till such time we are not able to come up with how do we deal with the legalities of artificial intelligence, we will not be able to deal with the copyright issues pertaining to artificial intelligence. Why? Till such time, I'm not clear, shall we give legal status to AI or not? It's hard to really straddle AI with any respective rights, duties, and responsibilities. We've seen these latest cases where now almost all jurisdictions of the world, whether it's US, whether it's UK, whether it's Europe, or whether it's Australia, who are unanimous in their thought process to say AI cannot be an inventor. You only have now one lone dissenting voice, which is South Africa, which is saying no, AI can be an inventor. So in a scenario like this, till such time we don't come up with the legalities of AI, it will be very, very difficult for us to come up with the relevant garden walls on how the rules have to be set up for reimagining copyright in the context of generative AI.
Has anyone asked ChatGPT whether it owns the copyright of the work that it creates? Have you ever done that? I guess no. Someone did it. And the answer was this. In general, the legal status of claiming copyright over the output generated by me will depend on the laws and regulation in each country or jurisdiction. However, as an AI language model, I do not have the ability to claim copyright over any output that I generate. That is what the AI says. So that is very interesting. As the laws stand today, AI's creation is not accepted. So that is where we are.
Just picking up from our fellow speakers, I'm Sunita Tripathi. I teach intellectual property law courses at Jindal Global Law School. So as an academic lawyer and a student of regulatory science, my interest is actually quite peaked at understanding how an individual country is going to regulate AI and ML generated data. So we have examples of technological giants like United States, and of course we have China running in very close to United States there, Korea coming up with how to combat deepfakes, etc. But one outlier and a technological giant as well is Japan. And it's being cited as coming forward with a precedential regulatory form where it has denied copyright protection for data sets that are actually used for AI modeling. And it has done that because there is a lot of AI startup work happening there, where AI modeling for various purposes, including educative purposes. So Japan is sort of being cited as an outlier because it has refused to give copyright protection and refused to protect content creators' power over the material or the output generated from AI. What it has done then is, in its own words, contributing to what is known as information commons. So it's available for anybody to use the data set because they are not original works, it's really data sets and not really authorial as such, to then use it for modeling purposes, for various aspects, be it for education, fair use, in other aspects of research or not. So this is more than just an interpretation of transformative use of any work that's created by AI. It's more a step further. There's a governance model which is saying there is a non-IP dimension to these kind of works. And as consumers of information and users of AI, I think this is something we should be alert to, that there is a world outside copyright which is looking at these kind of data sets and is valuing its contribution. I think I'll start with that and then.
Yeah. Subhash, any opening comments from your side?
No, I have certain thoughts which I'll share when I'm coming to my topic. Yeah. So,
sure. Sure. So, and just as an aside on what Pavan mentioned about AI is, hallucinating and ChatGPT is hallucinating. Even if kind of mentally switched off in the evening because copyright is not your area, here is an anecdote which I think impacts every lawyer. Many of you would have heard of this name called Stephen Schwartz, and a lawyer in the US. And he just did some research. Instead of the Manupatra equivalent of the US, he went to ChatGPT, and sure as hell, ChatGPT came out with many case laws for the lawyer to cite. And he put it in the draft, he put it in front of the court, and he got ripped apart because all of those turned out to be fictitious cases. And not only was he, pulled up, but a fine was imposed on him. So as lawyers, please do bear in mind that end of the day, ChatGPT is essentially just a chatbot which is built on top of a large language model or an LLM. It is not a question and answer, tool. It is not a database. It's just a generative model which is spewing out what it is supposed to do. Natural sounding language in response to your query based on its own semantic search or whatever technology it is using to find out things which are adjacent in that area. And if it is not finding exact things, it is making up things. So please be very, very careful. These are things which, of course, all the disclaimers do mention, but the common man does not read disclaimers, and in this case, the lawyer also probably did not read the disclaimer. But we've spoken a lot about who owns the rights. But there are two sides to the coin. There is the rights, and then there are the duties. And when we speak about duties, there are a lot of duties on the people who are creating these algorithms. So Pavan, from your perspective, from your vantage point, what is it that the legal framework needs to be developed in India at least, in order to protect and in order to ensure that there is the right sort of liability and onus and responsibility on the creators of applications which are based on top of these generative AI models?
Thanks. Almost everybody in India who would be developing these generative AI models or new apps would qualify as intermediaries under Section 21W of the Information Technology Act. That being so, in any case, they are required to exercise due diligence while they discharge their obligations under Section 79(2)(c) of the IT Act. But with that, let me give a caveat. The IT Act was a 23-year-old legislation. It was never drafted keeping in mind artificial intelligence. So as we go forward, it will be very important for India to very quickly start coming up with a legal framework for, number one, legally recognizing AI, number two, for minimal enablement and regulation of AI, and number three, for the purposes of elaborating the rights, duties, and responsibilities of coders. Now, should AI go ahead and do some harm? There's nothing that I can do to AI. Although when I look at this recent study that's come in 2 days back from Yale, that tells us that out of a survey of 112 CEOs across the world, a majority of them feel that AI will be disastrous for humanity in the next 5 years. So, mind you, the time frames are going very quickly. 3 years back, they had said 2062 will be the time AI will supersede human intelligence. Last year, they said, sorry, 2062, it's going to be 2040. Now, this year, Sam Altman says, sorry, it's going to be 2035. My gut feeling is this is a tipping point that's going to come in by 29-30, in the next 5-6 years. So, till such time, you do not really specify the specific due diligence parameters that will have to be put in place by coders. It's going to be a lost game from the word go. Why? Because today, I can't have the coder or the company who's creating the AI algorithm to say, I don't know what I've created. Sorry, nobody asked you to create what you did, right? Even if it's an arms race. Yes, the Future of Law Institute, Life Institute is telling everybody, pause your experiments for 6 months so as to enable legal frameworks to develop. But nobody is pausing, no problem. You are developing, you are growing at your own pace. So somewhere down the line, what will be those due diligence parameters that these coders will have to adopt, will have to be specified by law. One option is either wait for a new law. Second option is government can still come up with rules under section 87(2) of the Information Technology Act 2000 and specify only specific due diligence parameters to be complied with by AI coders. But whether that will ultimately happen or not will be dependent on the subjective discretion on the political will of the concerned government. Because we are seeing a flip-flop. 15 days back, we heard a statement by the minister saying India will not regulate AI. And almost instantaneously, we came back with a U-turn saying, no, we will regulate AI, but we will look at more positive use of public good. We either have the China model. China is saying that I am going to audit every of your generative AI platform or algorithm that you're going to create. And once I'm going to audit it from the purposes of public good, and then I authorize it, please release it in the public domain. Else, you're violating China's cybersecurity law. Be prepared for a number of years in jail. Now, that's one approach. That may not necessarily work in India. But a more proactive collation of international best practices on what parameters of due diligence should be stipulated could be a good starting point. But mind you, we do not have the time. Whatever has to be done in the next 6 to 8 months. Otherwise, the train would have left the platform.
Absolutely. I think time is of the essence, and time is running out on our panel as well. But very quickly, before we move on to the next thread, reacting to one of the points that...
Just to add to what Dr. Duggal said, with the GPAI committee being set up internationally to control, or maybe it's directed towards the ethics of artificial intelligence, and India being the chair of the committee this year. So these are the steps that will, I think, make a directional difference, if not much, to that. And with the Digital India Act, the first draft that's out is basically dealing with, as you said, the IT Act is 23 years young, so they are dealing with aspects of from cookies to intermediary and how we're going to deal with them. So I think these are the things that we should look forward to in terms of guidelines and affecting the judgments directly for making an impact in, because things like artificial intelligence leading to deepfakes and all are really falling into a multitude of things, and copyrights is one of the aspects of that to be dealt with.
Yeah, absolutely. And yeah, what I was just saying was, even though theoretically you can say that the developer needs to own responsibility, today we have a situation with this breed of generative AI that Sundar Pichai has said that, he doesn't understand how the algorithms that Google has developed are behaving. And of course, it's not just him as an individual, it's the entire battery of developers, because that's the nature of this beast. And these are algorithms which learn on their own. So how do you control that? How do you take responsibility? Those are things which I'm sure will be hotly debated in the times to come. But speaking about the action on the ground today as we speak, Subhash, from your perspective, what are the challenges that you see today, as a practitioner, and what are the kind of things that you think need to change in the legal framework from a practical standpoint?
I'm Subhash Bhutoria. I'm a partner at KSK Legal. I'll try to answer it as a GPT to save my job. Yeah. So the idea is that, it's not an isolated statute or a law that we are looking at. We cannot just talk about copyright or any IP laws, but we have to look at it holistically from different aspects. AI has two aspects: the input data, the big data we are talking about, and the output, which can be deepfakes. So we're looking at privacy rights, we are looking at publicity rights, we are looking at different consumer rights involved. Now, taking an example or cue from what US has done in terms of CCPA, the California Consumer Protection Act, they have an option to opt out from the use of AI generative data. Now, this is something which is important because, as rightly mentioned by the panel, that you cannot probably regulate the creation of output or probably the development of AI platforms, but you can also regulate how this output can be used. So it has to be both ways, not just from the developer's perspective, from the owner's perspective, but also from the user's perspective. So that needs to be taken into account while developing laws and regulations around AI. A classic example is CCPA, and very interestingly, while we are talking about Digital India Act, while we are talking about the 2019 Consumer Protection Act, the definition of consumer rights in India does not have anything to do with consumers. It only talks about products and services. While you look at CCPA, it talks about how the consumer's personal data, personal information will be utilized. So that is a very important aspect to be included while we are framing laws around AI.
One aspect is, of course, about framing laws and what kind of laws get framed, and I'm sure the Digital Data Protection Bill and the Digital India Act, a combination of all this will probably set us on the right path. But coming to the implementation of copyright, which has traditionally always been a big challenge, given the nature of the creative artifacts that are protected by copyright, we've already seen so many challenges even with the earlier breed of technology. Kunal, from your perspective, what are some of the implementation challenges that you're seeing on the ground today? How is it that, when the rubber hits the road, when it comes to the copyright owners getting their bang for the buck, how is it being implemented? And there is certainly a huge gap there. So how do you see that gap being covered in the times to come?
Yes, so according to me, enforcement and implementation has always been a problem as far as copyright is concerned. Stopping someone from pirating your work is almost impossible, especially if the other side is not known. Over here, the other side is absolutely unknown. We don't know who that is. For example, let me take an example of piracy. Now, piracy, the first of its kind judgments by Delhi High Court had come in 2012, where UTV at that time had gone to court saying that there are multiple rogue websites, as they call it, have come up. They tried to stop, I think, 1,000 websites by passing an order and made Home Ministry also a party. The next day they found there were 10,000 more websites which had come up with the same content. Now, it is just impossible to stop all these things. The second difficulty has always been in respect of all the computer programs and these kind of things is that the servers are never located in India. Or for that matters, if America is looking at it, the servers would not be located in America. They would be probably be located in some obscure island somewhere which no one knows. So how do you actually go and stop all these things from happening? The third point is that, as Dr. Duggal also mentioned, that we have a concept of intermediary. The reason why intermediary came is because of this only, because you could go after an intermediary who's a known person. Now, what is it that the intermediary is doing? Intermediary is doing the same thing. He comes and says, sorry, I'm not located in India. I can't stop all these things. For example, Twitter, it does the same thing all the time. That is why the government of India came up with certain guidelines that no, you have to have a person who's responsible for all these things in India. Of course, there was an uproar about it. So enforcement has always been very difficult. Now we come to artificial intelligence. The other side is absolutely unknown. We only know the creators. The creators can say, oh, we just put in the algorithm and it's created something. We are not liable. We have our disclaimers. So again, the enforcement is going to be difficult. But what is important is regulating it at the right moment. Well, I don't say that stop all the technology at the moment because we don't know what law to come up with for regulating it. But regulating it at the right moment is the only answer. You may have a soft touch approach. You may have a self-regulatory approach, or you have a hard approach like China's adopted. Or you have bills like America, they have the Deepfakes Accountability Bill Act now in 2019. So what kind of approach India needs to adopt is for the government to see. But according to me, I feel that the light heart approach or a soft touch approach with respect to AI is not going to work. It'll have to be a hard-hitting approach where regulating it like a censor board will be needed. Now, of course, there are ancillary issues there of freedom of speech and expression, etc., etc. That has to be dealt with at the right stage.
I think, as we've also seen in copyright enforcement and, collection of royalties and licensing fees, etc., you need tech solutions more than, the legal frameworks and the judiciary to at least go after people and, monetize small amounts of royalty. I guess, there will be a tech-led solution which will have to solve these problems as well, because, loha lohe ko kaatta hai and, tech will have to come in.
AI will regulate AI.
Yeah,
that's what will happen.
Somewhat like that maybe.
Just to add here, in Copyright Act, it is specifically mentioned that you cannot assign something in a future medium, which is not known. So with the change of technology every now and then, it is, we need to amend the law to say that even future mediums should be identified in a way. It should be there.
Yeah.
So that's something which is very important when it comes to AI, machine learning, and so forth.
Correct. And the importance, of course, the focus of today's discussion in the panel is around copyrights, but as some of the panelists very rightly mentioned, the Malaise is much, much bigger than just copyright itself because of the social impact, the national impact, the economic impact on the people, what I like to call the zombification of humanity around us, with everybody glued into their algorithmic content. Which gives rise to the big question about what we are preparing the youth for, and that ties in very well to the theme of today's conference on the future of legal education. And we have Professor Sunita Tripathi here. So, from an academician, as an academician, what are you thinking of in terms of what is it that the youth needs to be doing and to be prepared itself better for the future that we are seeing tomorrow?
In a very positive sense, we are lucky that we don't have to instruct the youth much. It would be very elitist of me to sit here and say I'm an academic lawyer and I want my students to do this. And they very well would find their own ways to not do that. So that's an interesting way of understanding how the human mind, the human neural networks work. You find the most convenient and plausible way to find your own solutions. So that's where I think the vision, I would say, for us as consumers of content and essentially people who want to live in a world which is less fake and more genuine, if that's something that we want, then there is a system of understanding what would be a governance model or a way of conduct that verifies information. So essentially speaking, do you have the discernment, a very precious cognitive quality, to actually sever signals from noise when you actually see data and you understand how to verify? Because that's exactly the problem, the confusion or essentially fabrication. But this is not to say that fabrication is always bad. And from a legal perspective, I would say there's a lot of room and scope for research in understanding whether there is utility in fabrication. Because sometimes some models might be absolutely redundant, but they're in the market because they're protected by exclusive rights. So essentially speaking, fabrication might actually open channels for access in other areas. So that's where we have the inventive model of fabrication labs going into inventing various solutions. That's not copyright, but that's a part of intellectual property, which is understanding that maybe fabrication is valuable. So from that point, I think, just as a way of understanding future lawyers or lifelong students of law, lifelong consumers of content, it would be interesting to know how disruptive technology like deepfakes or augmented reality or even influential content is being managed. How is it being produced and who is exactly responsible and, for actually ensuring that the right data is being studied? Because even if you are an expert who has a professional responsibility to evaluate this information and can always be tricked by a good faith information deliverer or even an opportunist one, it's not necessarily deception at play. There might actually be good faith. So these are very nuanced legal concerns that from a governance perspective requires multidisciplinary expertise. It's almost a wicked problem as big as any other. But because we are talking about information integrity, we will have to have the tech lawyers, we'll have to have lawyers per se, learning the tools and the rules of the game. And that is really a difficult race, because law has always been playing catch up with technology. I think all of us know. So if law is supposed to be the latecomer in this dangerous game of information, then whoever is controlling this information needs to be regulated. And whoever is not ready to be regulated needs to also be told that you're not part of this game. And that's where I think if you start looking at information as a global marketplace, and you have these big tech-savvy giant regulatory systems coming in, whether be it from China, Japan, or even India later, and I'm hopeful India would be a sensible player in this game, given the diaspora we cater to, and our ability to make cheap technology, which is actually quality product being consumed, and our newest collaborative nature internationally. So our global presence is being taken much more seriously than I think ever before. I say this from a simple example. When we talk about deepfake, the biggest joke, I've just returned from Europe, was, and it's a very rude joke, that you have presidents who were erstwhile comedians with less political experience, a deepfake video being circulated commanding their own nationals to surrender to a foreign army. So this kind of political instigation is not protected by copyright, but is this supposed to be a societal problem? That's the kind of sensibility we need to see. And post-COVID, these new terms of infodemic and every other bit of arbitrage that's around, I think it really helps to kind of take a step back and know whether dehumanizing is really a convenient solution for a very dangerous future, or to be more vigilant. And even if you're an expert, you have the right to question the GPT in a way that it will not trick you. And that comes from cognition. I think I would say, take your law schooling very seriously. Learn what the law is saying, what it's not saying. What are you consuming as a consumer, and whether the law is really practically helping that. I would say, stop being too much of an advocate and start being a person who experiences this, because life is changing, as we say. And if we are going to be future regulators, or even the current regulators, our experiences will count. So our lineages and our patronization of certain political ideologies, that's not a place where governance can work, at least not for a bright future. So I would end at that.
Can I just come in and say that, look, life was easier when it was just ChatGPT. Now we are beyond ChatGPT. Look at GPT-4, look at Microsoft Bard, and you quickly realize that the transparency is getting more and more evaporated. You still have no clue of how these new models of AI are actually dealing with your data. So when I look at GPT-4, and that's what I've argued in this book, GPT-4 and Law, that look, you will now have to have more holistic and overarching legal approaches to deal with these new technologies. You'll have to force these companies to come up with a minimum level of transparency and accountability towards law. Otherwise, you don't know that your own profiles are getting set up by the said companies on servers located in another country. You have no privacy. More significantly, your exact informational clone is going to get developed, which is going to have a direct impact upon your human rights, upon your digital rights of existence, and the like. So I think we'll have to be far more holistic in our approach on how to deal with not just copyright, but other contentious issues of this new wave of generative AI. Thanks.
Any closing comments, Kunal?
So let me only say this. I heard Dr. Duggal say that these companies must stall the process until the law comes. It can never be like that. I am sorry to disagree with this line at least, because technology never waits for you. Technology is ever evolving, and it will always surprise you. The law is ever evolving. Law will also surprise you. As you said, Copyright Act is of 1957. It has catered to things till 2023. There are courts to interpret it in a new way. The laws are being interpreted in a new way. The question is, is this law not enough to handle AI? Yes, it is not enough because it is not a regulatory law. But as far as to answer issues pertaining to AI in those strict terms of copyright, it may well be answered as it has been answered by UK court. Not many cases are there. As it has been answered by Delhi High Court once, that a game created by AI does not enjoy copyright. It is the creator of the AI who has input those keys who will enjoy copyright. So the law will evolve along with technology. We can't stop technology. That is the only point I wanted to make.
Give your concluding comments as well.
Yeah, sure. You know, I mean, with this whole advent of technology, I mean, law always follows whatever is happening in the society and in the information age. Obviously, it's technology. I mean, there are various, that's the reason there are various rights like personality rights coming up. What was famously happened in the case of Mr. Amitabh Bachchan. So these are the kind of rights that will come up falling directly under copyright because we're sticking to the topic for today. And this is just one very small aspect of the kind of development that is going to happen wherein an actor has copyrighted his own personality just to secure its misuse at the end of the day. So a lot of it is in terms of a creator's economy, wanting to limit the laws to the misuse of their rights. And obviously with the deepfakes, you know, where we are questioning what is a person to begin with here. The definition of a person has come into question, wherein what famously happened in the monkey selfie case that we were discussing. So, you know, a monkey is not a person, so they don't get the right for the selfie. So, yeah, so, I mean, we're headed to very interesting times, and let's see where the acts and the judgments take us. Thank you.
And on that
I think the governments are also in awe of what's happening. Considering sedition has become a problem for them, so.
Yeah, and speaking of time, I think we've totally run out of time, so we'll not follow in the footsteps of the earlier panels, we'll stick to our timelines. But if there are any pressing questions, I see a couple of them, so we'll just take these two questions. We won't have time for answers, so you can ask your question.
Hi, good evening everyone. I'm Duggal. I'm a practicing advocate at Delhi High Court, working at the intersection of AI and law. So my question is on the concept of responsible AI. Like, I know it's a huge term, but specifically when we talk about in the field of copyrights and IPR, like this question is for all the panelists. What are the key thrust areas that you guys believe that are required when we talk about responsible AI with the concept of copyrights?
Even before we get to responsible AI, I think precursor to that, according to me, is explainable AI. The earlier generation of AI algorithms were by and large explainable when they were dealing with, you know, simple machine learning algorithms, random forest or what have you. But as these more complex, multi-layered deep neural networks have come in, and on top of that, we've got these transformer architectures which are at the base of today's models. Explainability is at a premium. It is not inbuilt into any of these models, so it is very difficult for anybody to claim that this is responsible if it is not even explainable and controllable. So according to me, that's where, you know, the tech stack, the tech world lies. From a legal standpoint, anybody from the audience wants to, anybody from the panel, sorry, wants to pick that up?
Thank you for that question. You're actually very much on point. So globally, we know very recently the United Nations announced that it's readying itself for the Summit of the Future in September 2024. And for that purpose, it's bringing in all the countries to kind of sign up to what would be the moral responsibility of AI developers. So this is a set of guidelines, so to speak. It cannot be mandated yet, but guidelines to kind of direct moral responsibility. So, you know, it's very interesting to see you're talking about technology, but you're infusing ethics and responsibility, and you're trying to pin accountability through that. But you're moralizing it, okay? You're not calling it a legal question, legal responsibility. So liability in moral terms. But like we know, morality and logical understandings don't really go differently. So to practically start at any level, even from a persuasive aspect, this is a smart strategy that the United Nations has played for a summit of the future. So why is this happening is because a lot of, I think, tech giants and otherwise are lobbying this agenda, saying that probably deepfakes is the most dangerous level of wicked problem, more serious than a sociological problem of a pandemic. So they're playing the COVID card and saying information integrity and the level of misuse for even political reasons is far more dangerous, can incite violence. And so moral responsibility has to be pinned at an individual nation's requirements. So what they're trying to do is, if you are a country with companies who are tech giants and there are AI developers who are creating a lot of and building revenue for you, you are also beginning what we saw in the early ages of intermediary liability. You're kind of bringing in a set of guidelines which you start as a soft approach, and then maybe we would have some kind of a hard rule later on, because you can't start with a hard rule because you want everybody on board, right? So the first thing I think that they have an agenda is a very practical point of disclosure. That is, you're actually disclosing the source of the information that comprises your data sets for modeling. So essentially, and this is not divulging to the public, but you're actually using that information. And so the author or the owner of that particular image or whichever data set is aware that that is being mapped by AI for whichever purpose. So there's a disclosure of intent. Second, there is a ability to always respond to audits. So if there are questions on compliance, how are you using this AI, for what purpose? So the purpose and character of the use of the AI or as a tool has to be revealed when you're questioned. So your denial in audit answers would be a signal that you are actually hiding something, which is very possible if you're using the AI for a malicious purpose, right? Third, I think, would be the idea is to actually, what are the measures you are taking to safeguard information? So there's sort of information secrecy or protection against information leakage. Again, coming from this fear-mongering that if this information is used or misused, it could lead to dangerous repercussions, incite violence, etc. Racial profiling is another problem that is which targets minorities a lot in certain countries. So these are problems that United Nations has been apprehended, and we see that moral responsibility clauses coming from a point per unit basis, but it's kind of scaled up to become a global issue. I think that's my understanding.
Thanks for that elaborate answer. The second and the last question for the...
Hello. Good evening, everyone. First of all, thank you for the session. During the session, in the correlation to copyrights, AI was termed as a modeling, hallucinative, or fictitious. These terms were used in correlation to copyright. But recently in Punjab and Haryana High Court, Justice Anup Chitkara actually gave a judgment while taking ChatGPT's help in the ruling of the opinion. So I would just like an opinion from the panelists about it.
You are a law student? Was it really a judgment?
No, I said opinion in the ruling.
Sorry?
It was an opinion in the ruling. They did not put it directly in the judgment, but it was like the opinion was taken from
it was just an order of bail, I guess. Yeah.
I think what's now going to happen is we're potentially going to follow what the Colombian judge did in February 2023. Now, he went much beyond. He tested a proposition, and then once the output came, he independently verified the same before he was able to pass the judgment. Now, while this is the direction which has to go, you already now see new developments. In the last 15 days, 3 district judges of the US have now mandated that every time you're now going to do your filing in my court, you'll have to give a certification that there is no output from ChatGPT or generative AI that you've incorporated in your pleadings, and if you have done so, please give a certification that you have independently verified the authenticity or veracity of the same. So don't expect ChatGPT or GPT-4 to be judges. They will never be judges. At best, they're like a torch into an area of darkness that can only give you a broad direction. But if you're expecting this to be judges, it'll be a different ballgame, although Estonia is begging to disagree. Estonia has already started using artificial intelligence algorithm as a judge for very, very small commercial claims up to $10,000. And that particular algorithm is deciding the matter. You're not satisfied with the judgment of the algorithm, you then go to appeal before a human judge. Now that's one way. Which way ultimately the camel is going to sit on which side of the road is too early right now to say. But yes, it's going to get more and more difficult for things like ChatGPT or GPT-4 to become judges, to play role of judges. It can still be at best a paralegal approach, but it may never be able to replace human ingenuity.
So I answer my question which I asked 2 panels back. Will it replace lawyers and judges? According to me, it can never, because apart from law, which is written in the books, when we stand in courts and argue, and I specifically refer to disputes, there are obviously a lot of emotions involved, not only from the lawyer's side, but even from the judge's side. Certain judges are sympathetic to human grounds, sympathetic grounds. Certain judges are very clued on to the law. Certain judges are equity-based, certain judges are not. Similarly, the lawyers are. Some lawyers look at a particular point in a particular way. So, to answer this question, whether we are going to be replaced, I think at the moment, the answer is no. But of course, technology has always thrown surprises at us, and it will continue to do so. Let's see what happens 5 or 10 years later.
Right, so we've got the final indicator that time is truly up. So with that, thank you. On the last thing that I would like to say in light of the question is, please note that ChatGPT is not AI. It's just one of the tools available in the marketplace. The area of computational linguistics and artificial intelligence is much, much bigger. So keep that in mind as you think about how man and machine can work together towards a more collaborative future, because that is really the essence of what we are discussing today, the future of legal education, multidisciplinary education inputs, leveraging technology. So don't keep it aside and don't sign affidavits that you will not be using technology or ChatGPT. With that, thank you so much to the panelists.
But do read books, don't always rely on ChatGPT. Read books, read old law, read old judgment. That'll help you more.